rid of my temptations. We are live, okay, so we've got it, and this is Senate Finance, we are back. This is just our first look at the family leave proposal. Our real interest is we have this proposal out there. I think there's probably a couple versions. And we have childcare coming through. And they all have price tags. And so we're just trying to get a handle on what the price tags are. I think this one may have a proposal for funding, but it also is one of the proposals for funding childcare. So this is just our first, we're just skimming the surface right now, and then we'll get deeper diving as we go. So Damien, you are here.
Great, thank you. For the record, Damien Leonard, Legislative Counsel. Before I start, Senator Rahm, am I allowed to discuss your bill?
Yes,
Okay.
I would say so. I'll like wave my arms
Okay.
the other way, but yeah.
Ledge Council is under strict guidelines about bills that have not been signed out.
No, I think
Yeah,
that's fair, and it's right here physically and extra technical about it. So
if somebody else says exactly the same bill, he can't tell you.
that's true.
Yeah. So there are two bills that I'm allowed to talk about today. There is the House Bill H66. There is a Senate bill that is pending introduction from Senator Rahm Hinsdale. The bills are very similar. At their core, they provide 12 weeks of paid family and medical leave insurance. So the important thing is that this is wage replacement insurance provided by the state. That's the key part of the bill. Both bills include wage replacement insurance for safe leave, which is leave related when you have to leave work due to domestic violence, sexual assault, or stalking. And it can be related to legal proceedings, relocation, recovery from injuries, things that may or may not be covered under traditional family and medical leave, but are crucial in those situations. The price tag for the two bills is slightly different. The Senate version has a lower price tag. It has a contribution rate of 0.5%, so 0.5%. The House version has a contribution rate that was just updated to 0.55%. The bill says 0.58. The latest projections have brought that down. Patrick can talk to you a bit about the modeling and how that's gradually refining. The main difference between the bills is that the House bill includes 2 weeks of bereavement leave. The Senate bill does not include that. Is there another piece that I'm missing? Which one?
Wage base.
The 25K.
Oh, right, there you go. And the House bill, thank you. I knew I was forgetting something. The House bill includes a tax refund for individuals earning $25,000 or less. So if you earn $25,000 or less when you file your taxes, or if you don't file, you can file a separate form. You can basically request a refund for your contributions from payroll into the program.
Okay, so the 0.5 is a payroll
It's a payroll tax.
contribution tax.
We can call it a payroll tax. It's called a contribution in the bill, but
On both the employer and the employee.
yeah, it's split 50-50. Employers have the option to cover some or all of the employee's portion, but they're required to pay a minimum of 50%.
Okay, so it's 0.25 on everybody.
Right, so for employer and employee, the default is 0.25%. Self-employed individuals pay the full 0.5%. So if you're self-employed and you choose to opt in, it is not mandatory. It's an opt-in program for self-employed. you would pay 0.5% on your self-employment income. The contributions are collected in the same way as Vermont income tax. So if you're an employee, your employer will withhold that from your paycheck, and then each quarter will remit the amount to the Department of Taxes. If you're self-employed, you would presumably pay it as part of your estimated quarterly payments to the Department of Taxes. The bill does allow leeway for the Department of Taxes to develop procedures around how that payment's collected in case they decide that there's a better way to do that from an administrative standpoint. Let me see, wage replacement in both bills is 100%. So it's full wage replacement in the bills, which distinguishes it from things like unemployment insurance or workers' compensation, which have different wage replacements. The other
100% up to.
yes. Thank you.
That's a really important part of that.
I'm sorry, I just finished testifying since 9 o'clock this morning in the
Right.
House, so.
I'm happy to
Appreciate
help.
your
I just don't want
patience.
you to
And
feel
we're
like
going
I'm.
to look at that tape and compare it to what you told us today.
Yeah, so I appreciate your patience with me after they've warned me out today.
And you've been breathing your own exhalation.
Yeah, so it's 100% up to the state average weekly wage, which is around just over $1,100. And then the taxable wages are, in the House, it's up to 2 times the Social Security taxable benefit maximum, which is roughly $300,000. In the Senate, do we settle at 1 or 2 times? One time. Okay.
What are you using for state weekly average wage, Jen?
It's just a little over $1,100. Patrick, do you remember the exact amount off the top of your head?
1,135. It's from the Bureau of Labor Statistics.
Yeah, so
And what does that refer to?
that's the maximum weekly benefit you can receive. So it's the state average weekly wage, and that's taken from the unemployment insurance program.
Yeah.
Annually, they look back at all the covered wages for unemployment insurance and then divide it out to a weekly average.
So if you make less than that per week, you get 100% of the wage you earn, not the 1,135.
Oh, okay.
But if
Yeah.
you make more than 1,135 per week,
That's all you
you're
can
capped at 11.
Yeah, okay.
Right, so this basically, you'll get 100% wage replacement, currently up till somewhere around 55,000. And then above that level, you're gonna see diminishing wage replacement.
Household or individual?
It's individual wage replacement, so it looks at the individual's
Just the
income.
person or person, so 2 people or,
Yeah, so the leave is tied to the individual, so
okay,
it's individual eligibility. There are no caps, like if you have 2 parents in a household, they can both take up to 12 weeks of leave following the birth or adoption of a child. They can take it concurrently, they can take it separately. It allows them flexibility with that, but the wage replacement they receive is based off of their individual incomes. So if you have one person in the family who's a high wage earner, they could be receiving the max. If the other person just works part-time, they could be receiving a much smaller weekly payment during their leave. And this all ties in with amendments to the current job protection law for family medical leave, which allows for unpaid job protected leave. And it ties into that by expanding the definition of family member to match up to the new law, and also by expanding the number of employees and employers who are covered. So at its core, the current job protection law applies to employers who have 10 or more, roughly 3/4 to full-time employees for parental leave, and 15 or more for family leave, which includes your own medical leave. And the new law would bring that down to 1 or more employees in the state, but then the requirements for eligibility require you to have either been working for that employer for a year at 30 hours or more per week, or having earned wages that were paid on which contributions to the program were paid for 2 of the last 4 calendar quarters. So there are 2 ways to get eligibility. This means that you could get job protected leave if you've moved to the state recently but are continuing to work for your long-term employer. You could get job protected leave because you've worked for that employer for more than a year, but you wouldn't be eligible for benefits because you've only been in the state for a month. Does that make sense? But if you're eligible for benefits, you're eligible for job protection. So it kind of covers 2 different scenarios with job protection, which is getting a little bit more towards the Senate Economic Development jurisdiction.
We're just trying to figure out how to pay for it. So.
Yeah, so with all of that in mind, the bottom line for you is that you're looking at contribution rates of between 0.5 and 0.55% under the 2 bills. Patrick can talk to you a lot more about the numbers. He's really immersed in that stuff to an extent that I am not.
Are there any potential issues that someone would challenge this based on different treatment of people based on the state, even though they are working for the same employer for the same amount of time?
So that's an interesting question. I don't think so, because eligibility for paid leave depends on your payment into the program. So eligibility for job protection was designed to cover both people who are from out of state and have moved to Vermont recently, and also people who have been in Vermont working for their employers for a while.
I mean, is there any requirement for how long they have to be paid in to be eligible?
It's 2 of the last 4 calendar quarters with no minimum payment. So there is the situation where you could have limited work for the same employer with a large break, but it fell in 2 calendar quarters. Most of the time, we'll probably see this benefiting folks in seasonal industries, where they might work in quarter 1 and quarter 4, but then during quarters 2 and 3, they're doing something else, but it's not working in Vermont. But they could qualify for benefits under the program and job protected leave, assuming they're working at the time they take their leave. So, and that's the other piece with the job protected leave. It doesn't explicitly say that you have to be working at the time you take it. This is something that it's not explicitly addressed in the bill. The way it's worded, you have to have earned wages in 2 of the last 4 calendar quarters. It does use the word employee, so there is a little ambiguity there, but that again is getting into economic development territory. I'm sorry, it's hard for me to stay focused on the funding issues. But yeah, so you've got a pretty broad group of people who could take the lead.
Apply to undocumented workers?
I would say no, because an undocumented worker is unlikely to pay contributions into the program. So if you're employing undocumented workers, you're likely not paying taxes on them.
Well, is the employer is responsible for making the payment? And what typically seems to happen is the employers are making the Social Security payments and are filing, even though fraudulent, Social Security documentation to the federal government, most commonly.
Are they paying income taxes?
No, they're all claiming to be exempt from income taxes because of the number of dependents they have. That's the typical scenario.
So they have to pay into the program to be eligible?
But the employer has to pay into the program, not the employee.
Right, the employer pays in and has to withhold from the employee's wages to pay in. So if those payments aren't coming into the program, you wouldn't qualify for the benefits.
It would be just an additional requirement for the employer to cover his activities as they are covering those activities now with the federal government by filing false social security numbers for their employees.
Yeah, I mean, the eligibility is basically tied to whether or not you contributed money to the program. And then your wage replacement is tied to documented wages that you've made contributions on for the program. So if the bottom line, I guess there could be instances where payment is made, but the payment has to be made to the program in order for you to qualify. So you won't have someone who hasn't made contributions to the program being able to then take state benefits.
Okay, other questions?
Yeah, I got a couple. So the seasonal worker example, would that person also qualify for unemployment insurance?
So there is a specific provision in the bill that says if you're taking unemployment insurance payments, you cannot receive family and medical leave insurance payments at the same time. It's a disqualifying provision, and it's required before you're determined eligible. The director of the program has to determine that you're not receiving either workers' comp for an injury that you're claiming program benefits for, or unemployment insurance.
Similarly, the frequency of claims. So in that same example, the seasonal worker, could that happen just perpetually every year? They pay into it for 2 quarters and then they draw paid leave in the sessions when they're not working? Or is there going to be some
They
limitation?
have to have a qualifying condition. So that's the limitation. You have to have a qualifying condition. Yeah, a medical condition, care for a family member, parental leave, or safe leave,
And then we,
or military leave. Yes, thank you for that. This bill also provides wage replacement for exigency leave under the Federal Family and Medical Leave Act, which is leave related to the deployment of a family member. Job protection for that is provided under the federal law, but this would provide up to 12 weeks of wage replacement for issues related to the sudden deployment of a family member or their return from deployment.
This is something I even had to have a light bulb moment around, but these aren't additive weeks of benefits. It all gets capped at 12 weeks. So you're not getting 12 weeks for taking care of a child, 12 weeks for taking care of a parent, 12 weeks for, I just want to make sure it's clear as we talk about the different types of leave you can take. Some are less than 12 weeks, but they would eat into your overall 12 weeks that you could take. And the most likely users of all 12 weeks are going to have a personal or family medical / birth issue.
Is that 12 weeks a year, 12
Yes.
weeks lifetime, 12 weeks a year?
Last time we had this bill up, or formed this bill up, one of the principal objections was that there would be a substantial number of employees who would pay in to the program, but would never be able to collect from it. Does that exist here?
There, like any other insurance program, there's the possibility that you pay in but never use the insurance.
Or are never able to use the insurance. In other words, you would never qualify. For example, there were, as I recall from the last time, everybody paid in, but you had to work a certain number of weeks or within the period in order to be eligible to pay in, or you had to have a certain amount of money paid in over time to be eligible. Now,
so this version of the bill does away with there was a wage threshold in prior bills. It's done away with that and replaced it with just having paid contributions in 2 out of 4 calendar quarters. So theoretically, if you only work in 1 calendar quarter, within the last 4 completed calendar quarters, you couldn't be eligible because you haven't made sufficient contributions. It doesn't look at the amount, it just looks at whether you made them. So there are going to be people who just can't be eligible because they work only in, say, quarter 3 every year or quarter 2. But if they work any other additional quarters in the year, that's considered sufficient to qualify for benefits regardless of how much work in that quarter, as long as there are contributions paid on that. So there are benefits and drawbacks to the eligibility systems that each state sort of employs. Some states use the dollar threshold, some use an hours threshold. We can't do that because we don't have the technology to track hours worked in our state. Some states were part of a pilot program from USDOL and have that capacity. And then we've opted for this third option, which is just tracking the basic fact of have you made contributions. We don't have to go back and administratively compile all those contributions. But it does mean that no matter what, there will be a threshold where some people may pay in some contributions and not be eligible. But I couldn't tell you how many that's going to be.
It's the same with unemployment. You
Yeah.
have to work a certain number of quarters and you may not be eligible if you've only worked 3 weeks.
Unemployment also has
My 2 weeks in
a,
the Alaskan fish hatchery did not qualify me for unemployment. Even though I never worked there and never submitted the claim, I was victim of some identity theft, as were many states.
But you see, the issue though is for the person who works for a particular quarter, they may be disadvantaged by not being eligible for a benefit, but they haven't paid any money into a system that they cannot benefit from, which is the case here. If a person only works in a given quarter
Yeah.
and you're having a 50-50
Okay, but it's
contribution system, well, yeah, but a 50-50 contribution system, I'm assuming that they begin to pay into the system, they're 0.25% beginning on the first day of work. And they pay it through the 1 quarter that they work. And then for some reason, they're not working with a temporary job or whatever, they can never collect a benefit because they haven't worked 2 quarters, but they paid in to the quarter that they work.
Just like
That's the
unemployment.
difference. Well, unemployment, the individual isn't paying any money into unemployment. The employer is, not the individual.
Okay, just the employer.
It's the individual who is not making a contribution that they cannot benefit from.
If you don't get sick, you don't get to collect on your health insurance.
Yeah, if you don't lay it off, you don't get paid, you don't collect unemployment.
Yeah.
But here, whether you get sick or not, you're paying for it, but you can never collect from it. That's my point. That was one of the problems that was in the last year's bill. However, a lot of that has been eliminated by the change that's been made this year, but there's still a class of people who will never be able to benefit from something that they paid into. That's just an observation.
This is a very new topic to me, and I wasn't here for the previous discussions. I don't know if this is the right conversation, but I need to better understand, and as much as you could point me in the right direction, how do we, how will we evidence and validate one's serious illness? Were there concerns raised about the validity of these claims? The flip side of the concern Senator Brock just raised, and similarly with safe leave and bereavement leave, what, you have questions in there. So is that in the statute? I haven't read the bill yet, it was just released. Will that be part of the discussion as to how those will be validated, that they are in fact a true bereavement worthy of getting 12 weeks off or however many weeks?
yeah, so for bereavement, which is on the House bill, not the Senate version, the director of the division would determine what sort of documentation they need to qualify it. With medical leave under existing job protection laws, your employer's is permitted, not required, permitted to request certification from a medical professional. So that can vary. It could be a physician, could be a nurse practitioner, could be your PCP, could be a specialist. For folks who, for example, Christian Scientists, it could be a Christian Scientist healer that's permitted under federal law. And that's actually something that our existing language in this bill, our state law is not as clear on that as the federal law. It was something that was highlighted, and then the House side was that current law in the state says physician, that dates back 3 decades and more to a time before we had physician's assistants and advanced nurse practitioners and so forth providing a lot of this care. The federal law is a more updated statute in that, but I'm digressing here. So you're allowed to get medical professional certification. The presumption is that Vermont, like the other states that do this, would require people to include that documentation with the application. The director is going to be able to set out by rule what documentation they want with the form. They're required to list qualifying documentation on the application so that people know what to submit. For birth or adoption, birth is considered to be a self-evident condition. So there, you don't need a physician's documentation. You just need to show that the birth occurred or is about to occur. So for example, someone who's pregnant, if they have a medical condition prior to the birth, they can bring in a doctor's certification for that. But the birth itself, all they need to do is just say, I had a baby. And the, let me think, for an adoption, it's adoption paperwork. So there are forms of documentation for these. And it's worth noting that Vermont is not creating this out of whole cloth, because we would be following a number of other states that have had the program running and can learn from their challenges and learning experiences on that. But a lot of this is going to be left up to the director sort of clarifying in rules and on the forms. This is what is acceptable documentation from a medical professional, a birth certificate, an adoption certificate, a death certificate, etc.
I will just say too, I was wondering if for some of these smaller, more miscellaneous categories, there was more of like a CTO bucket we could create separate from vacation, but a lot of businesses just kind of don't want to know why you're out. You know, they want to trust you or not ask that many questions. So if you're in with a lot of employers, they have CTO. We had, for example, a really beloved state employee who had issues with past iterations of the bill because he has like an adult son who was the victim of a robbery and was stabbed and rendered blind by this event, and went down to take care of the situation. And that wasn't covered in a past iteration of a bill because it wasn't a minor child. So we try to just, it looks like we're throwing the kitchen sink at this in some ways, but really it's like the reasonable person would just say, I get it. You know, I don't want the law to have to spell all of this out. No other state, to our knowledge, and you know, to the bill sponsor in the House, has more of like a flexible CTO version of this. They have to kind of be really specific.
What is CTO?
Combined time off.
Okay.
Sorry.
Get 2 weeks a year, take it for whatever you want.
Right. Mental health day, you know.
All is well.
Yeah. So I just went down that road because I wish we didn't have to be able to try and capture every single scenario, and then the 2 weeks of bereavement, like who are you grieving? I don't, you know, who's to say who that is? Yeah, I mean, gosh, my dark night. Not tired, you know, but yeah, I just want to say we looked at other flexible pathways.
When a qualifying event were to occur and be evaluated as such, is it always going to be 12 weeks, or will there be a variation of how many weeks are then earned? So to
Yes,
speak?
so you're allowed to take leave as needed up to 12 weeks in a year. So great example of this is, so I'll walk you through a sort of potential year. So you have an elderly parent who has an accident and needs a week of care, so you take a week. Later in the year, you or your spouse has a child or you adopt a child, so maybe you take 6 weeks then. And then maybe later in the year, and this was, again, a hypothetical just to show how you could use the leave. you need to take medical leave for your own illness. Maybe you're having back surgery, or you discover you have cancer, God forbid, and need to undergo treatment for that. And that allows you to spread it out. It can be taken in increments as small as a day. So that would allow for someone, for example, who's undergoing chemotherapy or kidney dialysis or something like that, to get that treatment in increments that they need, or if they have outpatient surgery related to a condition, something like that, they can take the day of leave, get wage replacement for it, and then go back to work. And that's consistent with the underlying job protection statutes, which allow you to take this intermittent leave if your condition requires it. In each of these cases, though, it's condition specific. So with a birth or adoption of a child, it's probably going to be a continuous block of leave. But for a medical condition, it's possible that because of the nature of the treatment, you'll need a few days here and a week there and a few days there, or maybe it's 2 days a month or something like that, all depending on what the condition is. And that's where the doctors or other medical professionals certification comes in, because that certification says, yes, they need to take the leave and it's going to be 2 days a month, et cetera. And same thing with the safe leave there. That could be, you may just need to show that on this day I'm meeting with law enforcement to discuss domestic violence. On that day, I have a deposition with a state's attorney, et cetera. And so you can kind of, again, it doesn't all have to be taken in that 12-week block. It fits the needs, but it's also flexible so that people are able to keep working. They can work on the intervening days. And that's consistent with the underlying job protection law. So it's worth noting that safe leave is a new proposal in this bill. That's something we don't currently provide job protection for. We provide protection for the court hearing and meeting with the lawyer ahead of time if you're an alleged victim of a crime, but we don't provide protection for relocating to a safe location, counseling, and recovery from injuries that maybe don't qualify as a serious health condition that would be covered under the traditional medical leave, and that would be covered by the new safe leave. So there are a number of different pieces in the bill, but I think for this committee's purposes, the bottom line is your tax rate and your price tag are slightly lower than what the House has for relatively similar benefits minus bereavement leave.
And if I could just say before we get to Pat, this decision about the 25K exemption on the House side that isn't in ours, if you do the math, that is sub minimum wage. It's not someone working a minimum wage job all year. It's someone working part-time, and the House is, and that we're splitting hairs a little bit. I've talked to the lead sponsor over there. She's not upset that we took that out. That's someone working one part-time job, and they never work another part-time job that adds up to more than 25K. It requires a lot of extra administrative cost to get everyone to submit their W-2s and their income verification, and then figure out, okay, this person between 3 different jobs made more than 25K, this person remains under the 25K, and do that refund. So it was more of a question, not necessarily, it has a small price tag, but it also has a huge administrative price tag, a huge additional administrative cost. And, yes, you might be working one part-time job, but, that's essentially on its own not enough to live on. So, I didn't see it as the people you're most worried about paying in and not benefiting. They will, frankly, they can pay in and benefit. In the House side, they don't pay in, but they can benefit.
You said
To the point you were just talking about, connecting with what Senator Ron Hinsdale mentioned about CTO, would you, is there expectation that should this get passed into law, that many employers that offer combined time off days, that they would recalibrate and probably maybe claw back or want to change some of those with their working conditions, relying on this program that their employees and they would be paying into?
That is a good question, probably for the employer community.
The economic development side of the bill, but it's not something where, just like childcare, if you're already providing childcare, we want to be sympathetic to existing situations. That's always come up, and there's been different ways of managing the response to that.
Okay, I'm at the conclusion here. I think I've gone off into the rough enough times here.
Things that aren't really our jurisdiction, so
Thank you.
some of us will deal with it in another.
Right, no, at least you know.
What, Patrick, money is our jurisdiction.
Great. Good to see everyone again. So first, Pat Titterton, Joint Fiscal Office. It's great to know that I could talk about the bill.
Yeah.
I
I
had,
don't remember when we last spoke about it.
yeah.
I didn't have the bill physically yet, so.
Right. So my original plan had been to sort of walk through all the different levers that can affect both the cost and how much, like, and on the funding side, what you have to set the rate at. It's more general, but I guess as we go through, you can kind of nitpick me on
Yes.
stuff that's in.
This
This
is just
bill.
our first pass through in this one, so there are levers that we can, is all, I have a feeling that like appropriations, all of these bills are gonna go on the wall. And when they're all here, we'll sit down and we will figure out how much money we can raise and how many levers we can move. And then we'll decide what we can or can't do. But there's several really social bills out there with significant price tags. And I think if we do this and do a payroll tax for this one, then we're, limiting what we can do, assuming that you just can't keep taxing employers. So I want to wait until everything is sitting here, then decide what and how we can divide it up. Assuming we can find money to tax or raise.
Great. So I have some slides that I can share with you all. Because this is sort of generally, you won't see any numbers per se on them, but they can be sort of discussion pieces for us. There we go. All right, so generally, and I know Damien already covered a lot of this, when you're thinking about constructing a plan like this, there's some very important decisions that all factor into how much you're going to need to raise and how much people are going to get. We've talked about what types of leave are involved in this bill. We talked about eligibility. That factors into the work in 2 quarters, part of the discussion. There are other parameters such as wage replacement, what the cap is, and then also getting into what the wage base we're talking about is. An important piece that we're having to make some pretty broad assumptions about right now because we need to work through some of those particulars that have to do with administrative costs. And we can get into that a little bit later. And then just this last piece, we've sort of touched on it briefly about the wage base and what that payroll tax is applied to, can make a pretty significant difference in what that rate needs to be. So, in the bill, in this committee, or in this chamber, I guess, you've got everything you see here except that bereavement leave piece. That's what's included in the House bill. And so, when you're thinking about what types of leave, you then start thinking about how much of it can people take. Are there caps for individual kinds? Like, for example, in the House, there was 2 of your 12. There's sort of a separate cap for that type of leave. But then, again, you're also talking about what Senator Ron Hinsdale was talking about earlier. We've got a bunch of different leave types. combine them all up together, like how much are we willing to let people take? Some states do it a little differently, where things like personal health, I guess Rhode Island is an example, they'll give up to even 30 weeks for something like personal health, but some of those other categories are much lower, the 2 to 4 to 6 range. And that's the cap that's working towards that goal.
Okay. And personal illness used to be covered under sick leave, which you could accrue in most places, so that when you did get seriously ill, you had accrued sick leave. In some places, you can even donate that to somebody who is seriously ill and has run through this. This would be in addition. So I suppose that would be up to the employer. They can say, okay, you've got up to X number of weeks, so I'm not doing sick leave. But, yeah,
We have 5 days of paid, we have 5 paid sick days
Yeah,
a year by law, Vermont.
not if you're a legislator.
Well, that all depends on how you do your finances here.
This
but,
is my only job.
Right, I just want to make that
Okay,
clear
so
that
there is
we have
five.
five sick days in law, and I would say the people who depart upward end up either calling it PTO or CTO, paid time off or combined time off. Or they do sick
So then you're
vacation.
sick, all right, we've got to, yeah, because I'm thinking an awful lot of sick leave I've heard of lately is my
Okay.
kids got a cold and got sent home from
Oh, yeah.
childcare, or my kid's running a fever, or it's not I'm sick,
Mhm.
it's my kids are sick.
Yeah.
And that first year they go to anything communal, they're sick all the time.
Right.
So that's, and just, yeah, how that all
Right.
works out.
And we economic development last year created a stopgap measure for that, called COVID relief fund.
Yes.
Where to help employers and employees who have taken those 3 weeks
Right.
because COVID cycled through their whole
Well,
house.
COVID, yeah, and there were 10-day
Exactly.
quarantines where if somebody had it, you couldn't go anywhere either.
But it was a patchwork during.
And, yeah, but I think it'd just be interesting, because somebody's going to say, well, if I were really smart, I could take 12 weeks of this, and then another 2 weeks of sick leave, and then another.
Oh,
That's
sorry.
part of my question is, so absent an environment where there is a collective bargaining agreement, if there is, in other states and with this, if somebody were to say, I'm very sick and I want to take 12 weeks off, will that be a protected claim, and that the employer couldn't just say, you know what, I'm sorry, I'd rather just let you go, and then they would have to claim unemployment insurance? Is that a very naive question? This is a new space for me.
So I'm gonna defer to
We're
Amy,
looking-
because
Yeah.
that sounds like a legal question.
Yeah, we're looking at the.
Yeah. So again, to claim 12 weeks of leave under the current Parental and Family Leave Act, or FMLA, you have to be able to provide doctor certification, or your employer can deny the leave.
Okay.
So if you can't certify the need to be out for 12 weeks, it's not just your word. You need to have some sort of physician or medical professional certification. I need to stop saying doctor. If you don't have that certification, your employer can deny the leave and your job is not protected. You can challenge that denial, but if it shows that you didn't have a protected serious health condition, and the conditions we're talking about here are danger of death, needing to be in the hospital, or in home under the guidance or direction of a medical professional. And so it's not like I have the flu. It's like I have to be at home because I'm recovering for 12 weeks from a serious traumatic brain injury or something like that. the other piece too is when that 12 weeks is up, you don't get to say, well, I've got 2 weeks of sick time. I'm going to take the 2 weeks of sick time. If your employer says, well, you just took 12 weeks of leave, I can't give you another 2 weeks, they can fire you. Unless you have some sort of contractual protection that prevents that, you lose your legal job protection after 12 weeks. And this bill includes language that specifically provides, and our existing parental and family leave law does, that says you can't extend your 12 weeks of job protection by creatively taking your annual leave or your sick leave or something like that. At 12 weeks, your employer can say, I'm sorry, if you're not coming back, I can't keep your job, and you're terminated. So
Okay.
Just,
did that cover? You sorry, great.
so yeah, you get protection now for family leave, job protection.
Yep.
But if you say, well, I'm still staying home, your job can end, your job protection only goes for that, is it 6 weeks of
Right.
family leave now?
So I gave this example in the House this morning. As a longtime state employee who takes very few sick days, I have this ridiculous sick bank. Probably not something I should advertise on YouTube, but I have enough sick time to exceed the 12 weeks. But if I took a medical leave at the end of the 12 weeks, if I still couldn't come back to work, the Office of Legislative Counsel could decide to terminate me at that point, and I'd have no protection and no continued right to my sick time. So because our job doesn't provide a right to cash out your sick time at the end of your work. So, and that's just the way it goes. You may have sufficient leave or other benefits to string together a really long leave, but that 12 weeks is your cap before it's up to your employer to let you continue, or some employment agreement that you sign, which might guarantee longer leave.
And Damien, it would also be true, is my understanding, because some of the unemployment advocates have come seeking a bill around unemployment, that currently, if you cycle through your existing time off because of COVID, et cetera, your kids have COVID, you're not eligible for unemployment either if you get terminated for that reason. That's been a request for legislation, but I could be.
Yeah, so it's unemployment's even more complicated, but the bill that's been put in on the House side on that, which I also testified on today, that essentially covers the situation. So where the best hypothetical I can think of is someone has a serious accident with a traumatic brain or spinal injury, something like that, that has a very long recovery time. They burn through their 12 weeks. They're still not ready to come back to work. At that point, if their employer doesn't say, I'll hold your position and you can use short-term disability, or you have a contractual protection or something like that, and they get terminated, the bill in the House would provide that that was no fault of their own if they had to leave. And that when they were finally able and available to go back to work, so they could do the job search and they could work again, if they couldn't find employment right away, they could apply for unemployment. But they would have to be able and available to work and doing the job search. It doesn't help them for those intervening weeks of recovery if their recovery stretches to 20 or 26 weeks. So.
Shall we
Okay,
continue?
we're back to you, yes. Continue.
So we've covered a lot of this already. We've talked about the 2 of the last 4 quarters. I have this example here because it's a very specific example. It doesn't stipulate that there has to be a certain amount of money earned within those 2 quarters. Some states do require a minimum amount of earnings to qualify. But obviously not here. One thing that is included here are self-employed individuals. Damien has talked already about how those are treated. But, you know, the decision to include them or not does affect, you know, what the expected benefits that would need to be paid out are. So, you know, it's an important thing just from that lens that, you know, these are people who could be taking benefit, but also need to be contributing into the program. So just again, looking a little further at some of the parameters, the reimbursement rate we said is 100% in both bills. Maximum weekly benefit is the average weekly wage. There is a provision in this bill saying that 5 days prior to your expected leave, you should be, you know, submitting the paperwork for it, and you know, within 5 days, a determination of eligibility has to be made. I guess in some cases that can go up to 15 days, but you know, in terms of waiting period, it's just important because you know whether you need to start immediately and have to be sort of backfilled or recompensated for the time that you were waiting for your eligibility to be determined. Just a factor there. We've talked about maximum number of weeks, and I think we've kind of covered everything else here. For administrative costs, there are kind of two considerations that are pretty significant. First being those ongoing costs, and that factors into that is what agencies are involved. Is it government run or is it contracted out to a private company? This bill is pulling in several different state agencies to sort of provide different tasks throughout that process. And then, you know, there's other things like the personnel that you need to hire in the IT system, like the upkeep of that system. One important consideration for all of this is whatever that one-time startup cost is going to be. Designing and implementing these computer systems, which are typically custom, can be hugely expensive. I think yesterday in the House, Joyce gave an example of Washington State, which I think their bills came out to somewhere around $80 million for their IT setup. I'm just giving an example of a large number that we've seen recently.
Well, Washington State is frequently, you know, that's where we compare ourselves, so.
Well, but there are also some other states that are sort of able to tack it onto existing
I was gonna
structures.
say the question might, would that, it would go through the tax department,
So I think there's a
They have the
nexus
best
here
computer
between
system.
Department of Labor, the
they have the
Treasurer's
worst
Office.
computer
Oh,
system.
am I wrong here?
It's tax, the treasurer's office and DFR.
Okay, they have good computer systems.
Yeah, so tax does the collection, and this is based on testimony from, I can't remember if it's the last iteration of paid family leave or the one before, but the testimony was basically about the difference between the tax department's computer systems and, for example, labor's. And tax has a modular system set up because every year there's changes to the tax code. So they need a system that's flexible, which allows them to handle changes at a much lower cost than, for example, the rest of the program. Your IT is going to have to cover eligibility, wage payments, and it's going to have to talk to the tax system. So that's where your expense is coming. You're not going to have necessarily, so Washington State, and I'm not an IT expert, but Washington State built a brand new top to bottom gold standard system with all the bells and whistles. I think a lot of other states have found other ways to do it. One of the things that you will need to consider as you're working on this bill going forward is just hearing from states that have done it more cost effectively and what their strategies were to keep that cost down. The one that we had considered in the past was this outsourcing collections to tax because they have that expertise. But again, I don't know the current cost of a new IT system. We put a placeholder in the bill for startup costs, but that's what it is a placeholder pending more testimony on this issue.
We could, of course, contract with people who don't provide healthcare for us.
I have questions on the parameters of benefit formula, but I don't know if this is the day to start talking about the legal.
Why don't we let Patrick finish? Because this is not, and other committees are gonna be doing all of that. I think we have the proposed funding source. We'll start looking at levers if we end up putting a 2% on payroll to pay for childcare. And then we're gonna be moving levers all over the place. It'll depend on what's there and what we think it's what the costs are. If what we think we can reasonably raise without burdening. And we'll do a cost benefit, I'm sure, not formally, but informally. And then start to look at the proposals and see if we can shoehorn something that fits. So yes, this is the easy part.
So I think that was good context. The 80 million figure that I threw out was more just to sort of show the scale. There is this other aspect that Damien was talking
But
about.
given the state of Vermont's experience with computers, I think only the tax department is a success. We have had, it
We've
has,
had problems there, although it goes back quite a number of years.
oh yeah, I mean,
Every major system that we've had problems.
we've had major problems, so.
Secretary of State's office did a great job with their
Okay.
corporate filing.
I don't think this
Major.
will go through. I did manage to do my sales tax all by myself online for the first time this year. So they have got it down to a real novice level where it actually looks just like the paper form. And it even adds up in rounds for you. So they're good. But yeah, they, that IT is a hidden number that could be substantial, could be minimal. And again, it'll depend on how many people sign up on day 2 to take leave and how, we'll work it through. All right.
So another piece that at some point you will need to think about is just, kind of similar to how UI has this trust. In times where you have surges of claims, you want to make sure that you're able to cover that with existing dollars. So that idea of a reserve will be an important thing to think about. But I'm sure we'll talk about that more later.
And what happens, yeah, we are getting the report from the UI Trust Fund next week, I think. What happened, maybe we raise the rates to employers when the trust fund gets down, or we borrow from the feds. Only once. So, yeah, that leaves open, I assume we would either have to scale back the program or raise the rate if the cost exceeded what we were bringing in.
So everything we've sort of talked about so far is what kind of comes in if we're thinking of a general equation on the numerator side, so that top half of the divisor. The important thing to think about when calculating your tax rate is going to be that piece on the bottom, which is your denominator or your wage base. In the House bill, as we discussed, it goes up to twice the Social Security max. So all earnings, wages, earned income going up to that amount is being taxed at that 0.58, well, newly revised 0.55 rate. But then, with some of the changes taking up the 25,000 exemption and going to 100% of the Social Security max. What's interesting is even though we're at half this, or half of the House's max, you're actually still expanding the wage base more doing that. So all of that goes into factoring into creating a larger denominator, a bigger wage base, which helps, bring that tax rate down. So the broader the base, the more money you're putting on that denominator piece there, the lower overall tax rate you're able to implement to cover those costs. And the one piece I think I forgot to mention on the last slide is we're sort of generally assuming a 7.5% cost of administration. It's the same assumption that was used in a previous, I think, 2016 report that Joyce Manchester was involved in over at our office. So, as we get more information, we'll be able to better fine tune that.
For self-employed, what is the difference between this and a self-employed person just putting money aside?
So if we're talking about it in terms of the wage base, I'm actually very happy that you just asked that question, because there is an important caveat to the current estimates that we have right now. We've been able to account for them on the cost side, so what benefits they'd be receiving. But we're still working through with tax how we would sort of think about what their wage base would be, or what we need to figure out to apply that tax rate, to come up with their earnings essentially for applying the payroll tax. So is that kind of get at your question?
Well, the employer, when there's an employer-employee, then the employee is getting something other than his or her own money.
Yeah.
With many years ago, I was self-employed, and there are certain advantages to it. You're your own boss. No one tells you what to do and so on, but the disadvantage is you're on your own. And it seems to me that the self-employed person is still more or less on his own.
Yeah, so I thank you for clarifying. In this scenario, self-employed individuals have the ability to opt in. Right, so it's kind of like they're buying an insurance policy in a way. The idea being that 0.5% tax rate, each month or quarter that they're making these payments to contribute to the program, ideally, if for some reason they do need to take that leave, the amount that they'd be receiving, it's like an insurance policy, it would cover some costs that they might not be able to cover themselves if they weren't making sort of the smaller ongoing contributions. So that's sort of the attractiveness from that perspective for those people.
It's been offensive for now.
Yeah, because most self-employed people don't pay unemployment insurance. And I had several very irate people call me and they couldn't get, I said, but you haven't been paying into unemployment
The
insurance.
nonprofits who did their own,
They
they were
did their
supposed to pay their
own.
own and they didn't.
But these were, self-employed people with profitable businesses. But now everything was shut down and they weren't profitable. And I mean, there's a certain amount of, well, I'm not paying that, over the years. And well, now you see why other employers are paying that. You're the employer and you didn't pay in. And fortunately, the feds came through recognizing that there was a problem. But that made my phone ring the first few weeks of the COVID shutdown. And
That was a kindness from Washington.
yeah, it was. But it kept people afloat who weren't able to work because we shut them down. And, but the unemployment, I don't think most of them realized that they weren't eligible for unemployment. So, yeah, so self-employed, yeah. I doubt that many self-employed people would do that other than a savings account because there's nobody matching them. And what was your weekly salary? I mean, you worked for a week maybe, you worked a couple gigs on the weekend, I did a couple shows, I sold stuff, and then it was 4 weeks before I did another one, and so,
Well, depending on the time of year, for me,
Yeah.
there was-
yeah, what was your weekly wage? That gets really difficult with some self-employed people.
raked it in for part of the year, and starved.
Yeah, you know, and, yeah. So, all right, so,
So that's kind of all to say is we are still sort of refining the wage base, which is gonna factor into the ultimate rate that we set here. You know, I guess just as to illustrate, one reason that on the house side, that rate came down from the initial 0.58 to now 0.55, is that, you know, Joyce and I have been working through and thinking about most appropriate ways to excuse me, make adjustments for inflation, which have been significant very recently. And it, you know, even just those inflation adjustments really do show that, you know, you're taking 0.03% off of that rate. So
what is the social security max right now?
it is, let's see if I have it written down here. It's about, I want to say 147 for this year.
Okay,
I'll
And
send
that's
you the exact
individual.
number.
yeah, so I'm not sure, why do you, because people that are making 200,000 a year are gonna be able to collect this. So you really, why aren't, I mean, I never understood the rationale, and I know whenever they talk about social security being in trouble, one of the things is remove the cap. Why,
Well, I think there's a cap on benefits. In other words, you
Okay.
may have a
So-
zillion dollars, but you can't collect on that proportional basis. There's only a certain amount that's the maximum that can
on
be paid
this,
out.
okay. There isn't on social security though, is there?
Oh, there is.
Oh, there is,
Yeah.
okay, then
Yeah.
that makes sense.
So the social security contribution and benefit base just went up. I'm looking at the Social Security Administration website. It was 147 for 2022. It's now 160, 200 because of inflation.
Okay, and I'm assuming that is all the wages you can collect social security on.
Yeah, so it's the annual limit on the benefits or the wages they use for your benefit calculation.
Okay,
So if you earn $10 million, they're only counting the first.
you're only
160.
getting social security based on the first 100 and whatever we set it
And
at.
so I'm assuming there's a concomitant cap on the amount of the maximum payout on a monthly basis as a retirement benefit also.
Yeah, so it's the annual tax base and the annual basis they use to calculate your benefit they're tied to each
They
other.
flow, okay,
Yep.
that makes sense, that's the first time I've ever asked that question, but it never made sense. And the impression I got was that people were only paying, and it used to be like 60,000, you know, but, I mean, it was a low threshold. Back when, if you made $15,000 a year, it was a living wage. I remember those days. But people are, yeah, so that's as much as you can collect. That makes sense. Okay. And this is the same way. You can only collect a benefit. Yeah, all right. You're not gonna collect more of a benefit if you're richer. You're gonna get,
You get capped at that 1130,
okay.
135.
So just talking about that social security max, you know, obviously we've looked at both proposals, one at double, one at 100%. And, you know, just at going 100% of the social security max, you already have a fairly broad tax base there. You don't necessarily add a ton more by going up to double. You do add some, obviously, but, you know, you're really capturing the meat of the bone by going up to 100% there.
Yeah, it's up to 160. Yeah, you are.
And yeah, there are a couple of states, a very small number that don't cap it. But I would say the most common practice is to go up to 100% of the social security max. So To do the estimate, we are using the same simulation model that was used in that 2016 report. We have had to bolt on a couple of estimates for this bill. We've had to bolt on our own estimate for safe leave,
And to what?
bolt on, add on, sort of do a offline adjustment. But it's this program that's great. It uses, census data and observed leave usage data. For example, we're using take-up rates, or I guess usage rates that are used in the state of Rhode Island, which generally speaking has amongst the highest take-up rates in the country. So, I think from that perspective, it makes our approach.
Let's take a break per capita. I
It's,
wonder why Rhode Island.
I don't know why, but they have the highest ones, and
Yeah. They're just also the smallest state, not in population, but in land mass. It's just interesting. Okay.
but the fact that we're using, the other highest states to take up rates, leads us to hope that this is somewhat of a conservative estimate, right? But, so it used to be, in that 2016 report, we'd have to go to this company called Impact to have them do runs for us. Department of Labor, US Department of Labor actually bought that software from them, and it's now available to the public. So we have had to do some sort of back end adjustments to it, but the basis of the model is coming from that. And I guess I don't have this slide here, and I'll stop sharing because I was expecting to do sort of a general run through.
That's fine.
But
This committee's getting spoiled. They're getting out too early.
the cost on the House side, which resulted in that 0.55, was around, and this included our 7.5% assumption for administrative costs, was about 86 million. When we make that change with the wage base and with taking out bereavement, it brings it down to more in the 80-81 range. So it's different wage bases, but that's kind of how the numerator is changing to make that difference in the payroll tax rate. So that's part of what's bringing it from the 0.55 down to the 0.5.
Any of your modeling so far with what you've seen in other states, do any states have a graduated or number of weeks off? For example, you would be eligible for 4 weeks after 1 year of paying into the system, 6 weeks after 2 years, be eligible for up to 8 weeks after 3 years, and so on.
I'm not aware of any state that's doing that. I think maybe something that kind of creates a complexity there is maybe moving jobs or working multiple jobs or something like that. So I haven't seen it similar to like if you work for a private employer, you're here 5 years, you get another week. You're here 10 years, you get another week, where they sort of build you up that way for vacation time. I'm talking about. So I can look at it, but I haven't heard about that like in years of service.
There isn't.
Okay.
We're tracking it when they pay into the system, or is just the employer track? Are we going to capture social security numbers knowing that, okay, so we would know if the employee has paid in at multiple jobs over how many years? Because we will be collecting centrally that social security number paid in regardless of which employer it was. So it's not unheard of to consider such a stepped earned benefit increase.
Yeah, I don't know. No other state has enacted it, but that's not to say that it couldn't work. It's just, the proposals have followed kind of a similar form that's generally tied to FMLA or the state's version of it. So the 12 weeks tends to be a default. And then there are states where you depart from that, like Delaware's new program is 6 weeks. Some states provide an additional 4 weeks if you have complications related to a pregnancy. So there are instances, I think Massachusetts provides up to 26 weeks if it's military exigency leave. So, the different states go different ways. So there's nothing that says that we can come up with something. And the last version of this bill tiered it based on the type of leave. So it was 12 weeks for parental, but less for family care and your own medical leave.
So, leave or something.
Yeah.
Yeah, but that's where we're gonna go. Can I, it's 26 weeks. Military, Senator, you're shedding notes.
Exigency.
Yeah, I can't say that word. What is that leave?
So that leave is tied to the deployment of a service member. So especially if the deployment comes at the last minute, you may have to race to make childcare arrangements. You may need to go to ceremonies.
Okay, so it's not covering you while you're in Afghanistan. It's covering, I gotta do a whole lot before I can get on that plane and ship out.
Right. It also covers instances where someone comes back from deployment. So it can cover the return. The reason it goes out to 26 weeks is it covers if the service member returns and they were wounded in action and they're, for example, at Walter Reed recuperating. The 26 weeks of job protection covers the family if they want to go down there to be with their family member.
Okay, is it just job protection or is it?
26 weeks of job protection. This
Okay.
bill proposes to provide 12 weeks of wage replacement
Okay,
for that. The federal law, if you're subject to that, which many employers and employees in Vermont are not because we're too small, you have to be working for an employer with 50 or more employees. That's a small number in the state. And then you have to have worked 1,250 hours in the past year for that employer. So again, we're shrinking that pool.
because I know one of the real problems is you get deployed and your military pay doesn't equal your civilian pay, but you still owe your mortgage and your car
Yeah.
payments.
This
and-
doesn't help with that.
Yeah,
So
and I know that's been a real problem. Okay,
I just, one sort of figure I had Pat look at, and I don't want to put him on the spot because he may not feel ready to share it. But it's an ongoing question for me is when you try to suss out a week of family leave versus a week of child care for an infant. Early estimates from Pat show you get a lower amount per week paying for someone's family leave to take care of their child than you do for putting an infant in a center. It can be less if you put them in a home care facility. But, Pat, I don't know if you felt comfortable sharing that number, but it's a number that I want to keep working on.
I have to figure out where I put that number.
I have it in my email, but we don't, it just,
Yeah.
it's an ongoing thing I can both
Yeah.
mark and they
and
should
this
be
is
looking at.
someplace where in financing it, especially since we don't have the childcare infrastructure right now,
Right.
rather than a childcare benefit, you get an enhanced.
Yeah.
I'm only going to mothers, but only mothers give birth, I'm sorry, and that does take a recovery time. But, I mean, if you're gonna cut it back that far, I mean, if you've gotta start
Right.
pulling levers.
Yeah.
So you're circling the notion of extending childcare leave that we get in this program, maybe be 26 weeks or something, and that would ultimately be cheaper than childcare.
No matter how many weeks you chose, just on a week by week basis, if you could pull that, like, you know, I'll just say this is my opinion. I mean, we turn kids over to childcare at 6 weeks, which is sooner than we make puppies leave. Mother, dog. So, you know, just the idea that you could have a humane solution from say 6 to 12 weeks that costs less than giving your child to a
Of course,
stranger.
the mother cat, after 8 weeks, goes and you're gone.
But yeah, you could start to look week by week, could you actually
Yeah, I
just
mean,
spend less and
these-
do the right thing?
We're trying to set up the social net, the
Right.
structure that allows families to function in a world in which everybody really needs to work to support a quality of life. A generation ago, one person in a family could work and could support a nice quality of life. That, my daughters don't have the option of staying home unless they want to live in a single life. To pay the mortgage and the taxes or the rent. And feed, clothe children costs money, and
then pay for childcare when you're done with
yeah,
your time with your child.
Yeah. So, we're trying to set up that structure that families used to, and for better or for worse, provide. Grandparents, I had lived on the 3rd floor, the Maidenhead. It was one in almost every Irish family, right? Those days are gone, and we're trying to recreate that security that allows people to function as humans in a workaday world. Okay.
So, as we've been talking about this has all come back to me, and I'm glad I don't have the number, because since I gave it to you, we have, been
That might be what
fine-tuning it.
Joyce was saying. I don't know, she said, I have more.
So like the basis of that estimate was built off of sort of what the implied daily average benefit is in this program.
Yeah,
So it's kind of, I can talk about it more when I come back, but it was sort of a comparison,
mhm,
what are the costs between the two, but
yeah,
yeah, I can refresh that. Bring it.
great. Yeah, I
I'll
won't
create
share it
that for you
because
next
it's
time.
your work that I want you to fill.
Well, I
in.
know
Yeah,
it's being kicked around in the hall.
exactly. I mean, I'm not kicking around anywhere, but the idea is,
Yeah, the idea is out there.
It is an interesting nexus with the RAND report conversations.
Yeah.
going on.
And they're all coming here.
This is the nexus.
This is where we get to pay for it. So, yeah, there's a lot of good ideas. And the question is, what can we do? Can we do it all? How do we do it? So I'm gonna, Senator McDonald, you need to draw us a cartoon. Because
Proposal for you.
I'll read it after we adjourn. Any further questions or comments? If not, we can go off live. I don't know if any of us have made out in time to see constituents. I know I've